All right, everyone. Thank you for being here. um, little technical difficulty, so we appreciate you being on time, even though we're struggling. For those of you that aren't familiar with this, if this is your very first time, this is an ongoing webinar series that we've been teaching for years, well over 10 years. We're excited, really excited to have my really good friend, Stephen Sumsion here with us tonight. Lawsuits are such a big part of what we do in lawsuit protection, but most of our teachings have been about the proper legal structures and how to avoid lawsuits. And a big part of that is what can we do before the lawsuit gets expensive? And maybe there's some simple things that we can do or less expensive things that we can do before we even get to the lawsuit setup. So we wanted to bring in Steve, who really is an expert in this. He's been practicing law for a very long time. And so, but before we do that, couple housekeeping little things. Again, we've had some incredible webinars over the last few months. We had Clint Coons talking about Wyoming statutory trusts. This is really important, especially for Californians who are trying to avoid the $800 filing fee per entity. We can do this legally, and we've had Jill Banner and Roberta Hootie on talking about they're managing billions of dollars in IRAs, and here's what people are doing to make money. We've had Chris Johnson on talking about grants and loans and scholarships, and right down the list, incredible webinars. Those are always available, usually posted about 24 hours after the webinar takes place on our YouTube channel. If you have not subscribed to that, let me show you real quickly how to do that. You'd go to YouTube. All of you know how to do that. You'd type in Protect Wealth Academy right there, and this screen right here will show up. If you hit the subscribe button, every time we post a new video, you'll be alerted to that and you'll be able to see that. So we encourage you to do that and subscribe to the YouTube channel. And then we have we actually have four 3-day summits coming up. Those of you that have been with us a long time, you know that we're bringing the very best of the best of the best. The best in asset protection, the best in the stock market. Here's how real estate ties in. We, for the very first time, we brought in Kwame Granderson. Well, actually, the first time in 10 years, we brought Kwame back. Venture capitalist, multimillionaire in real estate, but how to millionaire mindset. And he gave such an incredible presentation. Bill Danko, Dr. Danko, the author, co-author of the Millionaire Next Door, and Better Than a Millionaire. What is it? Richer Than a Millionaire now. His new book. Incredible messages that our presenters have. If you haven't attended a summit, sign up for that. The next one we do will be live stream. Orlando will be a live event. If you haven't booked your travel for that, we're really excited about this Orlando event. We've got an amazing Disney property, 5-star hotel for a very good $129 room rate. Live stream again in October, and then live event in November. We're not taking registrations for that yet, but we certainly are for the June and the September events. So if you haven't signed up for those, go ahead. The agenda is on our website, and you'll find that it is not a wussy little agenda. It is full on. We're asset protection geeks. For those of you that are professionals, almost always you'll get very nice continuing education credit for attending our summits. It's that impactful, but it's really designed for the average businessman, the business person. It is designed for real estate investors, stock market investors, medical professionals, the people, because we try to start at a very basic level, but we don't end up that way. We get you where you need to go. So estate planning, income tax reduction strategies, a lot of estate planning, but mainly lawsuit protection. So that's what we do. And then open Q&A every Thursday at 11:30 Mountain Time. You can adjust that. You'd go through Facebook, and I don't know, you look at us up on Facebook, and you get those invites to that little lunch. It's just we take whatever questions come about, and anything to do with asset protection, estate planning, income taxes. And then before we go, again, I'm really excited about tonight's presentation, but there's a legal disclaimer every time we do anything. We can teach correct principles, how those principles apply to you, and even if those principles apply to you. That's really for a discussion between you and a professional. Maybe we're going to talk about something that you think applies, but maybe it doesn't apply because you're in the wrong state, or your family situation, or your business situation, or your tax situation. We can teach general principles, and we'll try to be very, very clear, but always consult with an attorney or a tax professional before implementing what we teach. And so with that, I've known Steve for a very, very long time. He's been a good friend, and I've got tremendous respect for his skills as an attorney. I don't know anybody that has more war stories of business deals that have gone wrong, limited partnerships that have been set up incorrectly. Oh my gosh, the business law that he practices. I've got a lot of respect for Steve, and we've asked him to come on board, and he's actually in our office. And so he's going to take over and talk about dispute resolutions, how to resolve things before they turn into full-on lawsuits. He's represented both sides before, after, during lawsuits. What a tremendous background. Steve, I'm very excited to have you on. Can you hear me okay? Are you live and ready to go?
Warm introduction. It's been such a wonderful friendship. Don asked some tough questions. We've met with Don and Kendall, and they've really cut to the quick and said, Steve, you need to present content that can be useful, that every one of you are taking your valuable time to listen, that you can put this to practice. So the reality is that disputes are everywhere. And what the strength of this presentation is to how to apply the principles of getting to resolution. And litigation is the worst of them. Let's talk a little bit. Some of the realities here is we live in such a litigious society, and the bigger you are, the better you are at being a doctor, an entrepreneur, or a real estate holder. You're a bigger target that makes you vulnerable to disputes that can cost you in the form of litigation, and you need to be prepared on how to deal with these, small or large. Now, the cost, let's just look at how would you define litigation? Oh, that's a boring definition. Let's get to the real definition. It's the most expensive way to resolve a problem. Seriously, look at this. Look at the reality of this. The cost, according to the National Center for State Courts, the median cost is $43,000 to $122,000. And when you're paying attorney's fees anywhere from minimum $150, I mean, that's right out of law school, up to $500 an hour, depending on the geography. I mean, these are fees that you want to use strategically. You don't want to use that unnecessarily. Let's talk about how you do that and avoid the consuming nature of litigation that can last on average 10.4 months. What about those that go on for 27 months? I just finished the case just last week. It had gone on for 7 years, and the court awarded every single aspect of what we asked for, including attorney's fees, which is one of the most difficult to get, and punitive damages. But it took 7 years to get there. Can you wait that long? That's part of the problem. Okay, and then you got the appeal that's going to take at least 9.1 months. We have several cases on appeal right now that are 2 years before they get to resolution. So we're going to talk about how you avoid some of these. Okay, first step, You initiate the case when a party gets sued. And by the way, if any of you have been sued, we have a booklet that we're going to make available for free. Well, at the end of the presentation, you can get your own summary of this. You can have this presentation. You can have this very detailed summary of each stage of the litigation. I'm sure some of you know some of these details, but let's talk about the initial fact investigation. By the way, the most valuable time I spend is in the initial consultation, in helping the client sort through options, whether to arbitrate, whether to mediate, whether to call on the phone and just say, hey, how about if we meet and sit down to see if we can work this out? And you may think, well, why can't I do that myself? You can, but having a neutral as a lawyer, a neutral, maybe an overstatement, a new face that doesn't have the skin, doesn't have the emotion, can be very effective in helping resolve that. So meeting and conferring with your lawyer is one of the most valuable steps. Now, let's talk about the discovery process. That is drafting these initial disclosures, interrogatories. We're right now in a big case in Florida dealing with a non-compete, a salesman, a top salesman and a top COO moved out of Florida. They got sued for violating their non-compete, and we're dealing with that discovery process that can be very time consuming. So depositions is part of the discovery phase, and all this is recorded and documented, and this is the most expensive stage of the litigation. But how can it be useful? We're going to talk about that. It's not too early in our judgment to mediate or to make an attempt to settle. Many times, I just had another case that related to a purchase of a franchise that went bad. And the lawyer, there's not a lawyer on the other side. They've got two seasoned businessmen on the other side that are willing to talk to me. And we're talking about how we close down the business because it just didn't work without expending a lot of money in litigation. These settlement conferences can be over the phone. They can. I love to sit down face to face and just try to neutralize some of the anger and the frustration. All right, pretrial motions. Here, when you get to trial, that's when it really gets expensive. You may have heard of a motion in limine. Basically, that's asking the judge to say, don't even allow them to talk about this certain relationship. It's irrelevant and it's prejudicial. That's another aspect is a motion for summary judgment. These are some of the hardest motions to get granted by the court. 80% of motions for summary judgment fail. And the reason is because there are what the court and the rules say have genuine issues of material fact. So if you have a lawyer that says, I want to file a motion for summary judgment, get ready for a big bill because they're hard to brief just right, but they can be very effective. Got to be drafted properly. All right, now let's go to trial. Whether you're going to have a bench ruling or a jury selection, bench versus jury. If you're the underdog, if you're the small guy or the small person that is being taken advantage of, then you probably want a jury. But that has to be decided up front. You have to decide and notify the court and the other party and pay an extra fee, not much. But typically, if you're the underdog, you want to have a jury. Now, when's the last time courts in the U.S. had a jury trial? I doubt there's been, maybe by now we've had one, but it's been a year off because of COVID. But this is a more expensive process. If you're the defendant, you want a jury trial. If you're the small guy, you probably want that emotion from a juror to side and appreciate how you're being taken advantage of. I had a hearing this morning in a case that started 2.5 years ago. And we were talking about whether the court would order mediation or whether there would be a jury available in last quarter of fourth quarter of this year. All right, jury instructions, very detailed. They can get so complex, unnecessarily complex. So we're going to talk about how you avoid some of this complexity. All right, after you do trial, you're not done. Many of our cases result in the filing of attorney's fees and costs. Our last one was we requested 600 some odd thousand and got 80% of that granted. Then you've got the enforcement of the judgment and post-trial settlement negotiations. All of this takes additional time and cost. All right, so let me give you a quick story. This one just got resolved within the last 3 months. After 16 months of litigation, actually it was arbitration. After winning at arbitration, then we had to go file in court to enforce that judgment. In total, there was close to $1 million just on our side that was incurred. And then you had a very high settlement and were being paid over a course of many years. Okay, let's talk about the merits of mediation. You've heard that term, you've heard arbitration. These are tools for you that you can utilize in almost any dispute at every stage of the litigation. We had a question this morning that came in, said, what do I do? Luongo, Mr. Luongo out there had a question about, what do I do if the litigation has already begun? Am I sunk? No, mediation can be done at any particular time. And guess what? The success rate of mediation is greater than 80%. That's a national statistic. You can Google that. Just ask, how successful is mediation? 80% success rate. You cannot turn down that opportunity. Now, why do you want to do that? Because you can control the outcome of the litigation. You can decide what you're willing to accept or not accept. You meet privately with the mediator. The mediator goes back and forth to meet privately and to coordinate a solution that is mutually agreeable. Now, sometimes I've mediated cases as many as 7 times. I even had one case that went on for a 2-month jury trial. We mediated 3 times after that, rather than go back and do it again, because the judge, after 2 months of jury trial, was diagnosed with cancer. And he said, I'm going to have to get off this case in order to save my life. So good luck, parties. And that forced a mediation process. Imagine that. Our number one objective at Sumsion Business Law is resolve legal issues without avoiding that costly litigation and arbitration proceedings. So we at the very beginning are committed to helping you find a solution that avoids these problems. But when we have to go all the way, we've done it many times. And sometimes you just have to do that. How you respond to a demand letter is critical. We had a recent situation where there was a very strong demand, and they cited a case that actually that case turned out to be very helpful for our position. It actually made our case. And so being able to assess that legal letter that on its face looks very threatening, having the ability to maneuver through that and use their own arguments against them can be very effective in running through the. Yes, Don?
Will you explain what a demand letter is?
Well, that's any kind of a lawyer that sends a notice to you saying, and it may be not even necessarily be a lawyer. It may be a demand from a business partner that says, look, I've had enough. I caught you this, and we're going to do that. So that's just a very general characterization of someone that says, look, I'm about to hire a lawyer, or maybe they have hired a lawyer. I'm about to file a suit, and we're prepared to go to the mat on this. And how you respond to that through, instead of yourself having a neutral or a lawyer that can take the emotion out of it and diffuse those allegations, offer to meet and understand, that's a very effective way of responding to a demand letter. Discovery can be a very useful tool. Let me give you a recent example. We carefully drafted some discovery requests that we attached one of the documents from a bank statement, and we used it to show that they were engaged in fraudulent transactions. And we call these requests for admissions, or you've heard the term interrogatory. That's just a fancy name for a question that has to be answered under oath, or the production of documents. We already had the documents, and we used the request for admission where they have to deny or admit under oath and notarize a statement back. By putting that out there and requiring them to respond, it actually led to the resolution of that case and the payment to my client for a very large sum of money. Oh, you will have issues with contractors. How many of us have not had an issue with some contractor where there is some major damage due to either construction performance defects or other issues? We had a situation where the discovery ensued. We brought in a third party to assess, and that led to an agreement to mediate to find a solution and not have to go through all the other discovery phases and through trial. That expert witness attesting to the damage can be a very useful tool that you can see the writing on the wall, if you will, and avoid that further litigation. Now, here's one that led to summary judgment. We had a restaurant owner that sued a lessee, and the lessee, the argument was over whether or not he had left at the critical deadline. He was 2 hours after midnight, and the question is, after deposition, was it reasonable? Was it material that he was cleaning up 2 hours, that's 2 a.m., was that a material breach? Well, what we've got right now before the judge is a summary judgment motion that would allow the court to say, this is legally not a material breach at 2 a.m. That 2 hour difference is immaterial. So summary judgment, again, the odds are against us, but we've crafted it in a way that we are hopeful that the court will grant that. Now, why choose mediation versus litigation? Or arbitration is it allows both sides to be heard confidentially. And rather than be at the mercy of an arbitrator or a judge, each party can be involved in communicating with the mediator what's important. So many times in arbitration and especially in litigation, there are facts that you think are really relevant, but the court will exclude because of the strict evidentiary rules. This is a very big frustration for many clients. They feel something is so important that they want that neutral to understand. If you feel passionate about the motive or the background, prior bad acts are generally not admissible. But if there are these inadmissible pieces of the story that you want to have a neutral understand to be able to motivate the other side to a settlement, mediation can be extremely effective, far more effective than litigation. Okay, why choose mediation? The speed and the cost. Again, the thousands of dollars that are incurred in attorney's fees versus the streamlined approach and cost-effective alternative to litigation and arbitration. If your lawyer isn't talking to you about the merits of mediation, you may want to seek other counsel. It is just that valuable as a tool, as a client, to motivate. And you may not even, recently we had a situation where we've got a situation right now up in Oregon where they filed a case. We've got a motion to dismiss, and the other side said, would you be willing to mediate? And we said, you know what? Rather than go through the motion to dismiss, which we think the court would grant, we will participate in that mediation process. Up there, my client is traveling there from Utah to Oregon to meet face-to-face, or that was the stipulation. We said we want some face-to-face contact to resolve this. Now, typically it would be totally private or separated. Now, what's interesting about this is that the mediator, as we talked to this mediator, she said, I have a 90% success rate when I can mediate without the lawyers involved. I've rarely found, and I always offer, look, if you want to mediate without lawyers, that's fine. Most mediators like having counsel involved, and frankly, it gives lawyers a chance to really hear the strengths and weaknesses. Well, it gives you and your lawyer a neutral's assessment of the strengths and weaknesses of your case. So these considerations, whether you're at the beginning or even after a matter has been resolved, you're going to find this process very useful. And in fact, I'm going to go out so far, and then you see at the headline of this slide, it is the highest and best use of my time, even if there's no settlement, because I learned those strengths and weaknesses of the case along with my client to better prepare for trial if we don't reach that 80% success rate. Here are the pros. For arbitration, now you're going to think, wait a minute, what's the difference between arbitration and litigation? Well, in arbitration, you have a private setting, much like mediation, but in the courtroom, that's a public setting. And many of these agreements that you get from banks, if you have a dispute with your securities, or some of these templates or these this boilerplate that you sign when you go in with a bank, or if you're trading on Robinhood, they'll have a clause in there that says you agree to arbitrate. Why do they do that? They don't want everyone else to know about what's going on. It also allows for a speedy result and flexibility. The rules of evidence are much more relaxed. You get to choose the arbitrator. Both sides, usually what happens is there are five, and you narrow it down to one from five that are considered competent to and in the right geography to handle the matter. One of the other questions I had this morning was, what about the cost? You know, how is arbitration less expensive? In my experience, it actually turns out to be more expensive. Why? Well, instead of a free judge, you're paying for an arbitrator. Why would you do it then? Because of the speed, the privacy, and frankly, the big companies, they love arbitration because they know that a plaintiff, a claimant, will have to pay half of that arbitration fee. And that itself is a deterrent. So you want to be very leery of an arbitration clause if you're the small guy. If you're a big business, you want to have it in your agreement. If you're a doctor's office or a big business, you want to have an arbitration clause because that deters lawsuits by forcing them to outside of a public arena and into a private setting. Now, one of the big disadvantages of an arbitration is, over on the right side there, you have limited recourse. There is, well, I'm not going to say no appeal, but the bar is very high of manifest injustice and the like. There has to be a degree of wrongdoing that is very, very serious and very hard to get over that hurdle. There's no jury. Whatever that arbitrator says pretty much goes. He can get the facts wrong. He can get the law wrong. He could be dead wrong on the law, and that would nonetheless be upheld on appeal if you were to take that case to a district court, a trial court, from arbitration. All right, let's talk about how you avoid this. I love this summation, because these are tools for you to avoid litigation. I'm going to jump to a slide here. I love this saying from Benjamin Franklin: an ounce of prevention is worth a pound of cure. I so much believe in that principle. I even memorized it in Chinese. Okay, back to protecting your assets. Oh, by the way, in Chinese, it's 有备无患. Yeah, it's a very important aspect of being able to use your agreements to create guidelines for dispute resolution. I can't tell you the number of operating agreements that should have been, that they almost signed. And, you know, so many times we trust people. You know, we got our business partner and we've got our term sheet, 1 or 2 pages, or an email, hey, we're 50-50 partners. And they failed to get this documented in an operating agreement or in the asset purchase agreement. You know, they got, look, here, you buy this business from me for $30,000 and I'll pay you the rest down the road. Or, hey, you agree not to compete against me for 3 years. I'm buying your business. You know, these are things that need to be in documents that, prepared to be enforceable. You're buying a business or you're buying something that requires that degree of protection. And likewise in your estate planning documents. They're critical clauses. You know what a crummy letter is, and you know, all of these different types of legal language that actually can be an ounce of prevention to avoid the kind of costs that we've talked about. I spent the first 5 years of my career with IBM, and they had this system down right. Their agreements were tight, concise, and friendly, and not onerous, not these lengthy agreements, but really targeted for what the business needed. Let's talk about having this mediation or arbitration dispute resolution clause, and also the attorney fee clause. If you're the underdog, or if you're feeling the other party can take advantage of you, the attorney fee clause, which basically says the prevailing party can recover attorney's fees. Of all the clauses in agreement, this one has turned out to be the most important, not just because it's an attorney fee clause. It's really that a client can say, okay, your fees are reimbursable. And when I make a phone call to the other side and say, by the way, there's an attorney fee clause at play here, I have authority to settle this matter with you without the fees I've incurred so far, if we can get the principal paid within the next week. That has been very effective. If I don't have an attorney fee clause, then I'll tell you right now, I've got the biggest, most reputable firm right now trying to get me to mediate, trying to get me to agree to resolve this matter. There's no attorney fee, there's no document, there's no signed contract. And the threat of filing a lawsuit against my client is not a threat because there's no attorney fee clause. Now, you need to understand that in order for attorney fees to be awarded, there needs to be either a contract with a clause for an attorney's fees, or there needs to be a statute. If you don't have either one of those, so many of our clients say, I want the principal, I want this much, and plus I want your attorney's fees. Well, if you settle a matter, understand that you typically will give up your attorney's fees first in order to have that resolution. Another reason why you want to mediate early. All right, drafting agreements. You know what, we're to a point here. I think we should engage in listen to a few questions if you would like. So feel free to fire away with that. We're getting into some war stories here, but let's hit a few more slides here. Don, feel free. If there's some questions you want me to address from the audience right now, I'd be happy to, before we jump into some of these agreements.
All right. What do you do when a mediation agreement has been reached, but one of the parties refuses to abide by it afterwards? What do you do with that?
Oh, this is a great question. This is one of the most favored motions that you can make before a judge. It's called a motion to enforce the settlement agreement. We've probably done it, I'm going to say 20, 30 times. And judges are very willing to take a settlement agreement, a mediation result, if it's in writing, that is going to be strongly favored. Right now, we are on a case in the Court of Appeals over whether a case was settled via email. And the question is whether the controlling Utah law is, when it refers to a subsequent agreement, does that by itself take it out of being a final binding settlement? But when you've got a signed agreement or even an email exchange, that can be deemed as a settlement. But enforcing that with the court is one of the best motions that could be made.
Good. Describe what binding arbitration is.
Well, binding is redundant with arbitration. Arbitration is really another form of litigation, but with relaxed rules that allow you to present evidence in a less formal way. And it can be, the process can be much faster than certainly than a jury trial and even a bench trial, where the rules of evidence get in the way sometimes of you being able to tell your story. You'll hear objection, hearsay. And those hearsay rules can be very complicated. That is out the window in arbitration. You get to tell your story in a more natural way without interruption with all the objections.
If somebody asks you to agree to binding arbitration, so you're bound at that point if you sign for that. What's the dangers of agreeing to binding arbitration before we even start?
Yeah, the danger is the cost of having to pay for the arbitrator versus a free judge. And if it's up against a bigger party, a bigger company that can afford that cost of half, and in some cases it can be split among the number of parties. But if you're looking for a speedy result and you want it private, but if you're the underdog, if you're the small guy, you want that binding arbitration is probably a negative. You would love to be able to make it public that this company has treated you poorly. That motivation for them public to have to answer for how they've treated you and to have that free judge. So making an overture for binding arbitration, you want to think carefully about whether you accept that. That is not likely to be real appealing to the normal consumer.
I noticed that a lot of states will allow doctors and dentists. Whenever I go into a doctor's office or dentist's office, they want me to sign a binding arbitration agreement that we're not going to sue them. We are going to. I know that's not legal in some states, but in Utah it does. And I've been very hesitant about signing those in advance. They haven't seen me.
That is a very good protection for the doctor. And candidly, I've not experienced that request, but right? We have made claims of doctors, a demand letter. And one case recently we handled, we got the full demand. It was immediately accepted. And then they hired a lawyer, and about 3 months later, they came back and said, "Yeah, we'll accept it." But that demand letter, if it's crafted right, can ultimately reach a very favorable result. But watch for those requests for binding arbitration.
Well, let me refer you to the doctors and dentists that I'm using then, because no, okay. Joyce is asking. It's my understanding that as far as statute of limitations, sometimes this can start the statute over if you speak to the party in any form, admit to the debt, agree or agree to pay a part of the debt. Is there some truth to that? Can it restart the statute?
Yeah, we actually litigated that very issue on appeal. And for example, if you have a mortgage, 30-year mortgage, and you don't pay for, let's say the statute of limitation is 6 years, there's an argument that they have exceeded the 6-year statute of limitations. But if you make a payment in between, that restarts. That's a way of basically what you're doing by making a payment within that time period. You're acknowledging the debt. And so that triggers a new beginning of the statute of limitations. So if it basically starts over again if you make a payment.
Cool. Juan is asking, can you mediate even if you respond after expiration of the letter? And I'm assuming he's meaning the demand letter.
Oh, this is a great question, because you get a letter from a lawyer saying you must respond by this date. Sometimes I consciously ignore that date and send it the day after, just to let them know that their deadline is arbitrary. And very typically, and when you get that letter and you see that deadline, as a client, my clients typically, we have got to respond within that time frame. Well, it's negotiable. Sometimes I'll pick up the phone and say, there's a courtesy call and say, hey, we're looking into your claims and we'll be back to you within the next 10 days, but just want to let you know we received your letter. That's a respectful thing to do.
It's a game that people play, and I don't know, in the companies that I've worked for as the vice president of legal and compliance, I don't know that we ever met the attorney's deadline. We would go, and sometimes we would ignore the first letter and then they'd send a second letter and say, this is our second demand. And okay, it's a push shove kind of game. And I'm not advocating you ignore letters, but it's a game. And the attorneys understand this. Even if it says respond by this date, well, it was in the mail, and so they're not going to receive it for 2 or 3 days anyway. There's a little push. I don't know.
Sure, there is, and along with that game, I make the analogy to playing chess. There are big moves with the queen and the rook and the knights, but then these pawn moves right here and there, that can be a very effective tool in motivating the other side to come to the table.
Yeah, those little pawn moves make a huge difference in the game, don't they?
Incremental progress, indeed.
Shirley is complimenting you on your Chinese. Can you represent people in Texas? You've mentioned Oregon, you've mentioned Utah, you've mentioned California. Where do you work?
I'm admitted in New York, Pennsylvania, and Utah. I can practice in federal district courts across the nation and pretty much any state with limitations. We do what's called a pro hoc vice motion, or a motion to the court with local counsel that will answer any questions or deal with local rules. I'm dealing with a case in Arizona right now. We've been in New Jersey. Basically, there is a little bit of an extra administrative challenge. In usually we'll hire local counsel to handle some of the very local practice needs, and that's usually not much of a burden. So Texas, yes. Would I pick a local counsel that's? Yeah, it's so easy to find a friendly lawyer to assist with local rules to fulfill those requirements.
Okay. Is there a difference between arbitration and mediation?
Very big difference. Arbitration is closer to litigation. It is almost, very similar in that the rule of law must be followed. Mediation, on the other hand, is a whole different, create what you want.
We're negotiating at this point.
It can be totally controlled by you as the client. You can say, I am done. This is going nowhere. I've had some mediations end within an hour. I've had others go many past midnight, many. You get so close, and you want to work out 1 or 2 or 3 page document that will be binding and enforceable, and you don't want to lose that moment. So, but you can call it, stop it at any time. You don't stop litigation or arbitration. You're stuck.
Okay, got it. If we
Unless you have
decide, if we decide to do mediation for monies owed, will that cancel my upcoming court date for garnishment filings?
Very good question. What you want to do is notify the court that you're going through mediation, and they will put a stay. In fact, just today, very interesting situation. We called the court as appellate court and notified them of an interest in a mediation. They responded back in less than 24 hours. We have a brief that the final brief, typically what you do on an appeal is you have the appellant brief, and then you have a response, and then the original party, the appellant, has a reply brief. The court put a stop on that briefing, a stay on the briefing process to allow mediation to do its magic. How about that?
Yeah.
That is belief in the system that I mentioned, 80% chance of success. So you want to notify the court that mediation is occurring and that request a stay, or you could probably, if you're pro se, meaning that you're representing yourself, you could call the court and say, hey, we're mediating, just want to let you know. And so put a stay on all proceedings. A phone call might do that if it's a collection action.
Cool. What should we consider when selecting a mediator?
You know, a lot of people think you need a retired judge. The judge is not going to rule on the merits. Look, a judge that's a mediator, they have skills in being neutral. They're honest. They have integrity. That's a great aspect. But what I see missing in the mediation process is real tenacity. I have, the beauty is that it still works 80% of the time, but I've had so many of these mediations that if I had a tenacious, really willing to pay that price of going in after midnight and getting the deal done, that commitment to finding a solution, frankly, I would love to be a full-time mediator in my retirement years, because I so much believe in that process and feel that it's the best way to resolve disputes. But that quality of being a retired judge is not necessary. It doesn't even need to be a lawyer. It could be again, this is a process. You don't have to have a license to be a mediator. There are all kinds of trainings you can go through, but it could be an ecclesiastical leader, if you could get one to do it, or a banker, or a businessman. Normally, however, our mediators are lawyers.
Okay. Can an arbitration ever be amended or repealed?
An arbitration or a mediation?
It says arbitration, but let's talk about both.
A mediation is lock solid. You're stuck unless the essential terms are not in the terms of the agreement. An arbitration is very difficult to have appealed. I've been down that road multiple times, and 90% of the time it's rubber stamp. It has to be, again, the rule of law doesn't really matter. There can be manifest injustice. That's really the bar. If it's so serious, so egregious, outrageous, the extreme of manifest injustice before the court will say correct, or an error. If there's a mistake or a correction that is obvious, there are certain time limits, but it's very, very difficult to appeal an arbitration ruling.
I think we did that one. Sorry. Does a Wyoming LLC help with, is it deterrence?
Well, any LLC or operating agreement for that LLC will help deter a lawsuit. Why? Because you have provisions, the contract terms that make it clear what the parties' rights are. What we see so often are these situations where the parties had a series of negotiations, maybe even a term sheet, a few emails back and forth, and didn't actually put together a final operating agreement. This morning, early at 7 a.m., I was talking with a client that this was a $10 million business, and the parties had emails reflecting their agreement, but no signed operating agreement. And the big debate was, do I say I will not take this additional action until I get a signed operating agreement? My client happened to be a minority member in that LLC, but that is such a critical phase for enforcing rights and strengthening your position so you don't have to incur all those legal fees that we talked about at the beginning.
Steve, I've run into that hundreds of times where our students say they have an LLC, but there's no operating agreement. And the example that I use is, would you ever set up a corporation, get the articles of organization filed? So now we have, permission from the state to exist. We do the EIN number so the federal government knows, but you didn't do initial meetings. You didn't appoint presidents. You didn't, there was no bylaws. There was no stock issued. You don't have a corporation. You have permission to exist. And I see that happen a lot with LLCs, where we filed articles of organization, we got an EIN number, we set up a bank account, and we started running a business, but we don't have an operating agreement. You really don't have an LLC at that point, do you?
Yes, that's true. Don, we should go through a quick little chart here while you got a few more questions looking over those. I want to go through a slide that talks about the pros and cons of each the various type of entities. Selecting the right entity can be extremely important. LLC has the benefit of being very flexible, whereas the corporation is less flexible. I mean, annual minutes, board meetings. I'm clicking through all my war stories because we're answering questions that really address this. But okay, here we are. Sole proprietorship, you definitely don't want that for tax or liability. Yeah, you've got flexibility. How about the next one? Partnership? Yeah, this is a good choice. No, not for liability purposes. Tax-wise, tax is a problem as a partnership, as you may know. Still got the flexibility. How about a limited partnership? This is actually better for liability purposes. As you know, the general partners are liable, whereas the limited are not. Tax matters. You still, there's some good reasons for doing a limited partnership. Again, flexible. Now, corporation. We love corporations for the corporate veil. And taxes. This is an interesting situation. You've heard that corporations are double taxed. We know that the U.S. tax rate for corporations is up for increasing under the Biden administration. But that boardroom structure can be very cumbersome. I don't know if you all consider a nonprofit, but in Utah, 3 board members are required. And this creates a structure that can be very cumbersome. So here's stiff indeed. Limited liabilities, love these for providing the same corporate veil, minimal taxes, and you can elect whether you want to be taxed as either a sole proprietorship, never do that, partnership, do that, subchapter S, or as a corporation. So why wouldn't you take advantage of a limited liability setting where you have no obligation to provide minutes or annual meetings and have the maximum flexibility and still have the corporate veil? To me, it's the no-brainer, the desired entity. Well, before we get to the closing here, Don, any other questions?
Yeah, let's go back to here. Have an S corp. I started years ago. Wanted to amend my operating agreement, so I'm assuming that we have an LLC taxed as an S corp. What's involved? Can I modify myself? You say that smaller landlords or small businesses should not do binding arbitration within the court. I think we got two questions. So how difficult is it to amend an operating agreement?
Yeah, not very hard at all. Just have to have all members sign the amendment. And that could be, really, it can be informal. You don't necessarily have to have a lawyer. You could go in and say, amended and restated operating agreement, and just change, if you've got the Word document, go in and make the changes and have everyone sign. Or you could do a first amendment to the operating agreement dated blank. Instead of John Doe getting 80% of membership interest, his is reduced down to 20% because he failed to do this or that, or he wants to retire. He's going to take $5,000 a month over the next 20 months in exchange for reducing his interest, or whatever it is. It may be that the CEO is, or instead of being a manager-managed LLC, we're going to go to a member-managed LLC, or whatever the change is. You can do that with the 1 or 2 pages instead of recreating the whole new document. The key is having everyone sign.
So we don't leave anybody out. It's a private agreement, so we're not going to notify the state in most cases.
Good
unless
point.
we're changing a member or a manager. Some states want to know who the members are, but that's rare.
Yes.
If we're getting rid of or adding a member, we would probably need to notify the IRS. But generally, it's a private
through the
document.
K1. Through the K1.
Correct. But it's a private document that you can amend yourself if you need to, but it has to be in writing. This is verbal agreements, and emails don't work to amend an operating agreement. Is that right?
That's correct. Yeah, and it'll state that right in. That's a requirement.
All right.
Now,
go ahead.
No. Well, I was just going to summarize with, here's our team, and Don says, hey, Steve, can you drop the $750 to $499 for the first 5 that send you an email? I really find the first consultation to be the highest and best use of your time, my time, and just to get acquainted, to see if we're a good fit. Love to help. We'll send you some literature. But that consultation, if you got a problem, love to brainstorm. I don't care where you are in the world. These are basic principles that apply in any state, generally, especially mediation, where there are the least amount of rules. Arbitration, more. Local litigation can be the most challenging. But intellectual property, trademarks, love to do trademark work. That's a national register, very valuable for your business. We love trying to help you minimize these problems. Even though we litigate cases, really my forte is helping you craft agreements that will minimize that exposure and help you with that tool to avoid the cost of litigation. But if you have to go that route and you're in it, get a mediator, find a solution, and through that neutral to help avoid that cost. Don, thank you for the privilege of being able to address some of these common problems and issues and provide solutions.
Talk to me about your consult one more time. If I go to a personal injury attorney, they're going to do the consultation for me for free. So they want your business, but they're taking 40-50% of the potential winnings. Talk to me why this is different.
This is different because when we finish with our consultations, a good many of our clients go off and take care of it. They don't need me again. So I'm giving in many instances, a very strong guidance of outlining options on how they can solve the problem themselves and what tools they need to get there. And that consultation can be the most valuable part of the whole process. So we consider that to be a requirement. We haven't been offering free consultations. And if someone comes in, they've been sued for $10 million, yeah, we'll meet with those people without a consultation fee. But our office has been requiring a minimum consultation fee, and we'll waive or reduce that to $4.99 for the first 5 of you that send us an email. What's that information you want them to send it to? You've got
Kendall,
that on the...
Will you put that in their chat box if they're interested in a consult? It's protectwealth.com/something.
BLU. Yep, protectwealth.com/BLU. And that is available right now in the chat screen. Just go ahead and click on that link. And so just to clarify that the first 5, we had a few questions coming in. First 5, then get that reduced fee. Is that correct?
That's right.
So what does BLU stand for?
Business Law Utah.
There we go. BLU, Business Law Utah. So, all right, let's go back to some questions here.
Sure.
Is it true you only typically have 90 days to take legal action after a demand letter is brought to your attention?
No such. That's an arbitrary 90 days. I don't know where that came from. The shortest statute of limitations that I can think of would be a year. I don't know any situation where you would have a requirement to respond within 90 days or take action within 90 days. Now, it may be that you signed a contract that said, if you don't provide written notification of your position within 90 days, then it will be construed as an admission that you owe this money.
Okay. So for a debt, perhaps.
Perhaps.
Okay. Allison is saying if you send a complaint, if they send a complaint with a date, when do you have to respond? At what point can they do something else, like a summary motion? If you've got a complaint letter, or at what point do they have to respond? And if you never do respond, what can they do?
That's called a default. And these deadlines are real. If you get a summons that says you must respond within 21 days or 30 days is common. And by the way, that 90-day for a debt, you'll typically see as short as 30 days. You respond within 30 days with a dispute. Otherwise, we're going to consider that admission that you owe the money. So that's the one qualification. But back to the question of what do you need to do within certain time frames? Remind me, Don, where were we?
If they send a complaint with a date, now, they're not qualifying if this complaint is coming from the court or from the attorney, and
Right.
that could make a difference. What if you do nothing? What if you don't meet their proposed deadline?
Yes. So the complaint will have the court header on it, but it'll come by constable service of process, and on the summons will say how long you have to respond. You do need to abide by that. Now, frequently when I get those and it's the day before the deadline, lawyers have professional courtesy and you can call and get an extension. And that's one good reason you want to hire an attorney, because there is that ability to get additional time. But the court could, if you don't respond within that deadline, then the other side will file what's called a motion for a default judgment. And the courts readily grant those. Do they do it the same day? No. Can you get them set aside? Yes. Can they be set aside for excusable neglect? Yes. But you don't want to have to go through that process. I did that. I've done it a number of times. And then in most cases, courts are loath to issue a default, or they're quick to set aside a judgment where there are good faith defenses. But you just don't want to have to go down that road. Answer and respond within the deadline if you get a summons and complaint.
Okay, can a subpoena also be ignored? Let me be clear. We're not ignoring summonses. We're not ignoring subpoenas. Sometimes we ignore a demand letter from the attorneys. That's different than when it's coming from the court.
The subpoena is
The subpoena.
the lowest of the requirements. They're just looking for information. Have I seen a court issue an attorney fee award for not responding within the time frame? Yes. Usually a small amount of fees, $1,000, $1,500. But the general rule is if you're in good faith trying to provide the information, and it is helpful many times if you get a subpoena that looks really onerous, to hire a lawyer to call and negotiate. Look, what are you really looking for here? We don't want to spend the next 24 hours chasing these documents down. We'll give you what you really want, but and frequently you'll get them to say, well, really what I want is that operating agreement or that financials for the last 2 years. Oh, okay, you want that? And then the lawyer will negotiate. If I give you that, will that be considered a full response? And they'll say, well, we'll let it go for now. And if we need more, can we come back? And so a lawyer can be very helpful in negotiating terms that make that onerous subpoena acceptable and workable.
Okay. Ruby is asking, do you charge an hourly rate? Ruby, he's an attorney. Yes, he does. Do you accept contingency fees? Yes, but everything starts with an initial consult. Is that fairly
That's
accurate?
true. Yeah, we try to make this attractive on the front end. Again, it's going to be the best use of our time. But I'm one of the few lawyers. The larger the law firm, generally, the less likely they're willing to take a contingency fee case, unless you're in the personal injury space. But business cases generally aren't done on contingency by large law firms. I'm not willing to take that. I am willing to take that risk, especially when there's an attorney's fee clause, because we've had a high success rate in being able to go after those successfully. But candidly, to start off with a consultation first to get to know each other is how we start. If someone out there is saying, I wonder if Sumsion would take on a contingency case, I got this idea, I think a consult would be appropriate first to assess, but we are willing to take risks that other firms are not.
But Ruby, there's a difference between business law and personal injury, and Steve is a serious business law attorney. So anyway, mediation. In mediation, can a mediator advise the defendant party that they should file a countersuit?
Yes.
And is that legal?
The rules of mediation are just so wide open. Okay, you do have confidentiality, that is sacred. Everything in a mediation proceeding cannot be used in any way, shape, or form to advance your case later on. That's a very strict rule. Why? So that there'll be open, free, and flowing communication to try to resolve the dispute. But that question of whether or not, remind me, Don?
In mediation, can the mediator advise the defendant or one of the parties to countersue?
Yes, and I had just had that happen. I talked with a very, very expensive mediator. We were planning to use him, and I laid out the facts, and he said, Steve, until you do more discovery, I would advise you to not mediate. You've got a strong position, and you need to go deeper. And I thought, well, that's very strong. That's a very strong opinion. He can advise. They'll say they're not advising. They will say, hey, have you considered this or considered that? And the process is just so extremely valuable to be using the services of a mediator to help give you a second opinion. Your lawyer may be telling you one thing and the mediator is telling you another, and somewhere in the middle may be the right. And you need to hear that, because That mediator, remember, that mediator is talking with the other side. And so he is filtering it to some degree, but that's a really effective way to know whether your case really has the strength that counsel may be telling you, your own counsel.
Andres is saying, I think he was on the other side, and the mediator is advising the other people to go ahead and file a countersuit. And he was going, is that legal? And can the mediator do that? And the answer is yes. Yes,
it is. Yeah, it's not common that a mediator would do that, and they try to be as neutral and engender confidence from both sides. So I can understand why you would be frustrated that, hey, why are you saying that to the other side? That actually is getting in the way of us solving this. That's prolonging this process. So, here's an interesting question for you to think about. What mediator out there is willing to, for lack of a better word, guarantee success? I've researched this extensively, and I've presented it to a board or a panel of mediators about whether there's any one of them that would take a case not on contingency, but based on a success fee. So you pay an initial retainer, both sides pay $500, $1,000. And typically that would be paid as an hourly rate. But what I want to know frequently is whether that mediator is going to be confident in bringing a resolution and giving a success fee by both sides in the event he is able to achieve that result, is something I frequently wanted, and I've actually done. But so many times my peers are not interested in that. The process just works, and hourly is fine, but I'm one that really likes that success fee as an additional motivation, because I find that my mediators just don't have quite the tenacity that I would like in some cases.
All right. Joyce is saying, for violations of the Fair Debt Collections Act and also obtaining a default judgment and a lien placed against property without our awareness, have you had success in cases such as this? Court documents were never received, U.S. mail, or personally delivered, as has been stated on court documents, and a default judgment and a lien secured without our knowledge.
Okay. Have I personally succeeded in that very situation? I've not had that. I've been close to that kind of a situation where I've been concerned that would be a claim made, but we were able to overcome it. I was on the other side where I was very concerned that the other side would claim something like this. The issue is due process, the Fourth Amendment. There is a need to be on notice with the debt. If you don't know it and you've got, the question is whether the other side can prove that they used a constable. It's the typical rule of thumb is you need service of process through a constable to prove that there was notice of a debt, or some other, there is what's called alternative service. It could be that someone dodged service and they made a motion, the other side made a motion to the court for alternative service that could be done through the mail. Basically, you need to look at what they argued before the court, because a typical judge will look and see what proof is there that this party received notice that there was a debt. Is email or Facebook? There's some controversy over whether Facebook will ever be deemed acceptable service, and it's just not. There has to be, in almost all cases, some service of process by a constable needs to occur unless there's been a motion for alternative service. So the answer is you should seek counsel on that one. Would be happy to visit with you on your options on how you challenge that. To say, look, if I had known about this, the fees, attorney fees, and the debt would have been satisfied. And now you're asking for 3 times more what the original amount is, when I never received notice. That's a very effective defense, and would be happy to visit with you about your options there.
Okay. Does an out-of-state holding company that owns LLCs make sense? Oh, whoever's writing this, we use that all the time. We use single member LLCs in the state where, let's say, properties are held, all held by a Wyoming or Nevada holding company. We do that all the time in asset protection. We put an LLC in, let's say, Indiana, because it owns an Indiana property. We want to have standing in that state so that we can defend contract or enforce contracts and evict tenants. But that, who owns the single member LLC in Indiana? Well, Indiana doesn't provide charging order protection for single member LLCs. So then we go to Wyoming, Nevada, Delaware, Alaska, somewhere that does. So Steve, any comments on that?
Yeah, this is common to pick a state that has less fees. New York and California, your registration fees, filing fees and the like, especially if you're owning multiple properties, you want to minimize those annual expenses and administration. So that is a common strategy, to have each property in a separate LLC and to pick another state to register.
Right.
To incorporate.
Okay, one of our cruise buddies, hey Al, he wants your contact information for later if they need it. You can always, Al, you can always contact Protect Wealth, and we'll send. But protectwealth.com is your contact, your initial contact always. Whenever anybody's on our stage, we can get in touch with Steve. Gosh, known him for a long time, and we're happy to refer you to anybody. But his slide that you see on the screen has the name of his law firm. It wouldn't be hard to connect with him outside of us if you needed to.
Steve at businesslawutah.com. Very simple.
Okay. Attorney General's office suggested I have a case for violation against the Fair Debt Collections Act. Okay, we're still on the same one. In securing a default judgment and lien against our home without awareness. Joyce, this is going down a rabbit hole that's not everybody on the call, all 100 people are. So this would be a good one to do a consult with Steve and his group and see if this is, I'm not sure we can answer all this without having all the information. Is this the type of issue you've experienced or might consider a case on a contingency basis or not? I think you've answered that, haven't you?
I would. This is something that, here's the strategy. I would look at the papers they've filed and contact counsel and say, look, you got a serious problem here of not meeting the standard the requirements of the law for notice. And there are a variety of ways we can communicate that effectively to be persuasive and cause them to say, oh, well, in that case, then we will take a lesser amount. We'll take off all the attorney fees and the interest. I mean, that would be, if you acknowledge the debt and just say, hey, I'll pay the principal amount, that's a really effective way to finding a resolution. But get all the fees out of here before we are willing to pay anything.
Andres goes back to his dispute in Texas. Then why to go to mediation if the mediator can turn around and suggest they just sue you?
Well, the reason is, it's a very good reason, Andre, because what you want in that process is to understand not just the good news, but the bad news, to be able to calibrate whether you spend a lot of money chasing this case when the other side really has good claims. And you will hear from that mediator. I mean, basically, you can turn to that mediator and say, wait a minute, you're telling me to file a counterclaim. What about our side? We want fairness here, or we expect you to be as candid toward them and the weakness of their position as you are to us. Understand what a mediator's job is to tell each party the bad news about their case. They're really motivated to tell you what you don't want to hear. Why? To soften you up, to bring the two extremes closer to the middle.
You know, that's really good answer, Steve. Thank you for that. We've dealt, most of you have met on our stage, Scott Estel, a former senior trial attorney with the IRS. He's sued the IRS over 2,000 times. And Stevie's never lost a case. But what I love about him is he'll tell you when I'm sorry, he's honest enough to go, no, on this one, let's not litigate this. He'll tell you when to back down and when not to, which with the IRS is probably the hardest line. Is this gray area of the line, or is this a line I don't cross? I want to know where the line is. And maybe a good mediator or a good arbitrator will say, you know what, before you spend any more money on legal fees, you're not going to win this. Just back down. I think that's a really good. Thank you for that, Steve. I appreciate that.
You're welcome. And my style is I am an optimist. I am aggressive, but I try to be respectful of the other side and then escalate as necessary to bring forth a result. I'm not afraid to pull the hammer out, but why not try to do things amicably? And I will try to present, not just tell you what you want to hear, but also here's what the other side would argue in that case. You need to know that. That's part of the fee you're paying is for me to be candid and somewhat objective. But when it comes time to put the hammer down, to be aggressive and assertive. That's a balancing act. That's a challenge every day. It's what keeps us, that's why we practice law and never hold ourselves out as experts.
Ruby, can you represent in Florida foreclosure complaint where I filed first, but the lender filed another foreclosure complaint against the borrower?
Yeah, the real property issues in Florida wouldn't be my forte in Florida. That's a local counsel is going to be your better choice. Where the rules of real property in Florida, you're just going to be better finding a hometown lawyer that it could be a sole practitioner, depending on the amount in controversy. But I think that's going to be a better solution for you.
Okay. Question: if a notice of lawsuit is taped to a door on a home through which the party never walks, nor uses and does not see when he drives out, can this be proven as legal effective notice? There
are situations where you can, in certain states, every state has its own rules for if the constable attests in a statement, I heard people in there, I'm at this residence that this property is owned by this person, I know they live here, and you can tape it to the door. That's deemed proper service in many states.
Okay, cool. Thank you. But on a vacant property that you never visit, it probably wouldn't be.
That wouldn't work there.
All right, good. T, if an LLC already registered in a home state can be an LLC set up in another state, even if it's the same name. So LLCs, T, are like the names for LLCs are like license plates. You can have the same name in lots of different states, unless it's a registered trademark. When you go to register your name with the state, they're really concerned about three things. Is it a registered trademark? Is it a swear word or an obscenity? And is it unique to that state? And other than that, you can call your LLC just about anything you want to name it. As long as you stay away from those three. Steve, any comments on that?
Yeah, one of the recommendations I would make for those of you that are in the business of picking a name that is for a product or a service, this registration is very inexpensive. Uh, Frankly, the attorney's fees are $1,200, coupled with $350 or so government fee. For $1,500, you can get a registration on a trademark but it needs to be distinctive. You know, there's and it's not immediate. But what you can do immediately, if there is a name. I mean, this is so fun. One of my favorite areas of practice is to help come up with distinctive names. Here in Utah, we have a name, So Delicious, and for a drink. A drink shop. I mean, soda licious. You know, there are just all kinds of creative things you can do with blending and coming up with distinctive names and registering them for your product or service that can be extremely valuable as intellectual property that people will pay good money. I had one client that was bragging about the fact that he came up with the word bitchin' to use as a trade. He got it registered as a trademark. He put it all over shirts. And he claims he sold the company for over $1 million just because of that trademark being used in the surfing industry. Fun stuff.
There we go. All right, Steve, one more time. If they wanted to do a consult with you, Kendall, will you put that back in the chat screen one more time? They would go to protectwealth.com / what is it?
BLU. So protectwealth.com / BLU. Bravo, Lima, Umbrella. Sorry, not military guys. I know.
Business Law Utah. Okay.
There you go.
You can represent people in multiple states. But I think Steve's expertise, or at least what he showed tonight, is arbitration, mediation to avoid the high costs of mediation. So, Steve, any closing comments here before we sign off? We've kind of reached our 8 o'clock deadline here. We know that we appreciate you being on, everyone who's been on the call, but any closing comments?
Well, back to the old adage, whether it's prevention is the medicine. An ounce of prevention is worth a pound of cure. And your agreements are your first step to you pay me now or you pay me later. Pay me to draft a proper agreement, or the dispute process is just so painfully costly. But you do have many options, and having someone to just neutralize the situation and represent you through that process can be extremely valuable, especially on the front end, to see if you can get it resolved and avoid a nightmare. But so many of these people think that they want to hire the biggest, baddest dog out there, flesh-eating lawyer. And I read an article recently on, do nice litigators finish first? Reasonable minds may differ, depends on the situation. But so much of this dispute resolution is stylistic, and finding someone that can advocate for you but not alienate the other side. That's what we strive for, and it's a daily battle to balance that. Thank you, Don, for the privilege. Kendall, really the second time in 5 years. Look forward to another opportunity down the road. Thanks, Don.
We'd love working. Steve, I love your style, and here's what I love is that you're aggressive, you're very knowledgeable, you're very experienced, but you're an easy guy to work with. And I like that when it comes to a really good attorney. I don't need somebody that's in their face and is gonna offend at every word. I like somebody, the cost of mediation, the cost of lawsuits, and forget the cost, the mental cost.
Oh,
not
my
just
gosh,
the financial of going through lawsuits. I don't know when I've ever been more on edge with my family, with everything else, than in the middle of a lawsuit. You don't know the outcome. There's so many costs in family, in time that are more than just financial. If anytime we can lessen those effects and find resolution, I'm all over it. Steve, thank you for your message.
It's an honor, Don. Very, very privileged. Best
All right.
to all of you. Thank
All
you.
right. And thank you for being on tonight. Have a great evening. Good night.
Good night.